Welcome to School Psych Podcast. We're all super excited. I know that you guys are excited too, because we've had a lot of interest in the live events tonight with RSVPs and lots of people saying that they're going to be tuning in. So this is a really great topic, and we're so excited to have a very talented and knowledgeable guest who understands both law and school psychology too. So it's going to be a really fun episode. But my name is Rachel. I'm a school psychologist working in Maryland. I'm going to pass it over to Rebecca, who's going to tell you about how to participate tonight. Rebecca?
Hi, everybody. I'm Rebecca. I'm a school psychologist working in the state of Connecticut, and we would love for you to participate if you're watching live by just signing into your YouTube account and commenting right along the video. You do have to be signed in, but you should see the chat feature right next to your video. If you're not watching live, which we know a lot of our listeners listen on iTunes and Podbean and Stitcher, and or watch later on the recorded YouTube video, please feel free to comment and ask questions. We'd love to continue the conversation over time. We really learned so much through your participation, your thoughts, your experiences. So we are looking forward to all the connections that you make as you're listening to this show. And now I'm going to pass it off to Eric.
Hi, everybody. I'm Eric, and I'm also a school psychologist in Connecticut. And we are excited to have Carl Corbin with us this evening, who is both an attorney and a school psychologist. So I'd like to tell you just a little bit about him. He is a graduate of Bolt Hall, University of California, Berkeley's Law School, and also has the school psych specialist degree from Gallaudet University and a master's in developmental psychology, also from Gallaudet University. He is currently working as an educational attorney, assisting districts to avoid litigation through preventative educational planning, and is presenting workshops and developing trainings and presenting material to include prevention and legal updates. Mr. Corbin has successfully represented districts at various stages of special education litigation, including administrative hearings. He has assisted districts in responding to student and employee complaints, and also successfully represented districts with classified and certificated layoffs and other employee-related matters. We are excited to have him with us. NASP gets to have him present, and we've had a lot of interest in hearing about what he has to say about special education, law, and school psychology. So, Attorney Corbin, would you tell us just really briefly about your journey from school psychology to law before we get into the PowerPoint and discussion?
Sure, and welcome everybody. So you're at an IEP meeting, right? And so you're not an administrator, you're a school psychologist. And so at the IEP meeting, regardless of not being an administrator, who do all the eyes go to when there's a legal question, a complicated special education issue? The school psychologist. And so I found myself more and more in the role of taking the lead, or being asked to take the lead by my district at contentious IEP meetings. So I decided, why not just go to law school and have all my IEP meetings be contentious. And also in California at the time, and this is, as my daughter likes to say, last century. So it was around 97 through 2002, 2003 time period. In California at the time, we were doing a lot of assessments. And so I was doing over 100 assessments a year and really acting as a psychometrician, getting burnt out, frankly, not doing a lot of anything else. So I was looking around, and I became an attorney, and I've been doing this since 2005.
That's fantastic. We were joking just before we started that perhaps that would be an interesting avenue for some of us as well, following that same route. So that's fascinating.
Yeah,
well, I know you have some.
I'm sorry.
I know you have some PowerPoint presentation, and I think we have a few questions from ourselves as well, so we could get into that. And I know just prior to starting, we neglected to mention Twitter and a couple of ways for people to reach us. Rebecca, did you want to?
Absolutely. I forgot to mention to tweet using the hashtag PsychPodcast. Any comments or questions, you can just tweet right from your regular Twitter feed, or you can follow the brand new Psyched Podcast Twitter handle, which is at Podcast Psyched, and you'll see our little logo. And then also on Facebook on the School Psych Podcast page or School Psych to Your School Psychologist, you can leave a message, an inbox message, or comment, post to the page. So we'll be looking for comments and participation in all those places. Thanks so much, Eric.
All right, so I'm going to bring up the PowerPoint here, and we'll let you have at it. And I'm sure there'll be kind of questions as we go. And I know that you're planning on devoting some time for questions at the end. So we'll definitely get that in.
Absolutely. So first thing is, Eric just mentioned, in all seriousness, to become an attorney, you're looking at about 3 years full-time, 4 years part-time. School psychologist would make an excellent attorney. The same sort of skill set that you do for school psychology will be very applicable for being an attorney. Plus, if you're getting bored, you want to switch careers, a private law firm would love to have you. So that's enough about that. And then what I'm going to do now, you have the PowerPoint in front of you, is these are based upon various topics. I know Section 504 was very popular, and so was manifestation determinations. But I'm going to try and go through the topics that you have on the PowerPoint with questions and the such, probably about 30 minutes to run through everything, to still allow time for additional questions, and really to talk about Section 504 and manifestation determinations. That's more than I can do here. But I will mention that in Baltimore at NASP, I am going to be doing a 3-hour workshop all in Section 504 and a separate 3-hour workshop on manifestation determinations. Okay, cool, fun. So flip to the next slide. You saw the agenda, the law. Next slide. So this is what you have under federal law is you've got the Individual with Disabilities Education Act. And then kind of closely related to that is Section 504. So all students with an individualized education program, an IEP, are also going to be subject to OCR. So both a special education hearing and the United States Department of Education Office for Civil Rights, OCR, has jurisdiction. And I give you the acronyms there, OCR, and then OCR, OSERS, and OSEP, and you have the abbreviation in the PowerPoint, although people are listening to this, OSERS is the Office of Special Education Rehabilitative Services, and Office of Special Education Programs for OSEP. And then you have your state law, and that's the thing with the IDEA, is the IDEA sets a floor. The IDEA sets a floor, but your states can add on additional law onto that. So everything I'm going to share with you here today is based on the federal law. Your individual state may have its own peculiarities on issues, especially related to specific learning disability. So then you should have your administrative hearing is one mechanism. There's also a mechanism where a parent can file a complaint directly with the state. The administrative hearing does have the right, typically an attorney or a hearing officer, the right to have testimony, to have evidence for a compliance complaint. That may or may not involve testimony. It may be just simply sending documents in to your state agency. They issue a decision. If either party, the district or the parent, doesn't like the decision, then they can appeal it to federal district court. And I'm looking there, federal district court, your Circuit Court of Appeals, or the U.S. Supreme Court. In California, we have the California Office of Administrative Hearings. And as we were sharing earlier, pretty much probably over 60, 70% of the special education law in the country either comes from California or comes from New York, with our friends in Texas generating a lot of law also. Next slide. So if you want to know your circuit court, you have on this graphic here, for example, you can see the Ninth Circuit, the number 9 for California and the other states. The Ninth Circuit, for example, the one I reside in, is the largest by geographical area, largest by population, and the one that tends to be overturned the most by the Supreme Court because we're the rebels. Why I mention this and why this is important, as I mentioned earlier, you're school psychologists, you're smart folks, you're my colleagues, you know how to read. Please go in and look at the case law, especially in this day and age. Trust but verify. So if someone's telling you to do something, please ask for the statute the regulation or the case law that says, why is it you're asking me to do this thing? Because you want to determine, is this something that's legally required, or is this just a preference thing? If it's a preference thing, that's cool and that's fine, but you need to know the difference. If it's a legal thing, then you need to comply with it. And why I'm mentioning the circuit courts is where the law is gray or where the courts issue a decision, the district court and then your circuit court could reach a decision in the Ninth Circuit that's completely contrary to what happens in the Fifth Circuit. So we could have, depending on the part of your country, the IDEA being interpreted completely different. And then how does that issue get resolved? That gets resolved with the Supreme Court, with the most recent decision being Andrew F. Cool, fun, exciting. Next slide. And I'm just looking over here at some questions. Curious about his opinion on not using intelligence tests on African-American students. That is the Larry P. decision in California. It's unique to California. If you want more information about that, then you can, the CASP, California Association of School Psychologists, are having a convention in Long Beach in October, and they're actually going to have Larry P. there. The student from the test, or from the court case, will be there answering questions. But basically, my opinion on this issue is we should be able to use, as the school psychologist, IQ test as appropriate with any student, and to single out African-American students as opposed to Hmong students, H-M-O-N-G, from the hills of Laos, or students from Jamaica, or students that come from Africa or South America with also different cultural differences. It's strange to me that we're going to single out and discriminate against African-American students by not giving them a cognitive assessment. And that's all I'm going to say about that issue. Any other schools? Okay, I'm going to go on to child fine. Next slide. So child fine, and what you have there is the legal citation. What I'm going to try and do for this presentation, for everything that I'm saying, I'm going to try and give you a legal citation for what I'm saying. So school districts have a duty to conduct child fine. That means we don't wait for mom and dad to come to us and say, I think Carl has ADHD, please assess him. We have to be searching and serving, actively looking. Carl might have ADHD or might have a learning disability, so we have to go and approach the parent when a sufficient trigger has been reached. We have to ask the parent, can we go forward and assess the student? And in most states, if we think that no, parents requested an assessment, we don't think there's sufficient basis, we can go and deny the parent's request for assessment. We have to provide a prior written notice, sometimes known as a 7-point letter under 34 CFR 300.503. Turn to the next slide. This is a common misnomer. So the child fine, and as I was sharing with Rebecca, the child fine applies for students that attend private schools or public schools. Child fine, our duty to do search and serve and offer to assess, is not if the student were 100% certain that they're eligible for special ed. And you've got a slide here. This is a bunch of legal citations, but I'd like you to go down to the red highlighted. Pursuant to the standard, the appropriate inquiry is not whether the child should be referred for, is whether the child should be referred for an evaluation, not whether the child actually qualifies for services. So the law anticipates that you're going to be essentially over-assessing and having DNQs, do not qualify, because they'd rather you have a number of DNQs than to miss some students that would qualify. So that's child fine. Flip to the next slide, and I'm looking at some questions. What about when you work at a district where they won't provide a service you feel is necessary? Then if you're a nationally certified school psychologist, you have an ethical duty. You have an ethical duty to work within your system, to raise that concern. And ultimately, if you can't change your system, then you have a duty to either report out or switch to a different system, switch to a different employer. And that's really easy for me to say. But these are hard times, especially when it's a zero-sum game and there's limited funds. And I'm sure at your respective state affiliate or at NASP, they'll have a whole workshop on ethics associated with that. And then one more, does anyone's attorney for their district come speak at their staff meetings? That's a fascinating question, and I don't know that. I know I do a number of trainings. So the next is parents and divorced parents. So this is the legal citation. This is Title 34 of the Code of Federal Regulations, Section 30.30. We often think of parent, and this is who can consent for an assessment, who can consent for special education services. So we know the bio or adoptive parent, that makes sense for A1. A2, a foster parent if the parent's rights have been limited. A3, if the court has assigned someone to act as to hold educational rights. But look at number 4. I'd like everybody to kind of focus on this and be aware of this. This is an individual acting in place of the biological or adoptive parent. That's including a grandparent, step-parent, the aunt, with whom the child lives, but then there's a comma, or an individual who's legally responsible for the child's welfare, who may or may not be related to the student. And that could be depending on your state. California, we have a caregiver affidavit. Other states, you might have a power of attorney. So you might have the grandmother, the stepmother, someone else actually at the IEP meeting who can legally authorize assessments and authorize the implementation of the IEP. But if there's a disagreement between, say, the grandparent and the biological parent, if there's a disagreement, then I don't use the T word anymore, but number 1 supersedes number 4. So if there's a disagreement between number 1 and number 4, then the school district has to go with the decision from number 1. But Carl, what about parents who get divorced? Great, next slide. So this is from OSEP, and what OSEP, I mentioned them earlier, the Office of Special Education Programs, and they're a federal agency that issues guidance to the states. And so what OSEP said is either parent may revoke consent for a student for the purposes of assessment or for special education eligibility. And so school districts are like, whoa, hold on, OSEP, that's not what you mean. What you really mean is if a mom gives consent, then the only person who can revoke consent is the mom. If the mom gives consent, the dad can't just step in and revoke. You're not really saying that, are you, OSEP? Next slide. OSEP is saying that. What they're saying essentially is the vetoing parent prevails. If both parents have rights, and this is going to be legal rights, and if a parent's rights have been limited, you'll have a court order that should be provided to your school district explaining that. But in the case of a parent that objects, the vetoing parent prevails. And our friends at OSEP said, we appreciate that public agencies may have difficulties with this interpretation when both parents with legal authority to make educational decisions on behalf of their child disagree on the revocation of consent. Again, vetoing parent prevails. Next slide, please. So a fairly recent case from California on this very issue. Mom and dad had joint legal custody, even though the student resided primarily with the mother. Dad said revoked all consent for special ed. Mom filed for hearing to have the district implement. The Office of Administrative Hearings said, we have no authority here. Where one parent objects, it's as if both parents object. So what's the remedy for this? The remedy for this is the parent who wants the services needs to go back to court and get a modification of the child custody order. And I'm just here to tell you, if a divorced parent goes into court and goes to the judge and says a school district would like to provide special education services, but my ex-husband, my ex-partner is not providing consent, the court is almost certainly going to give consent for that to occur. But who has to do that? That's the parent has to do that. The school district has no ability to take to court and force special education services where a parent has completely revoked consent for assessment or denied consent entirely. Next slide. And then I'm going to look at some questions.
Carl, can I jump in with a question? I'm wondering in cases of litigation between parents, if there's a restraining order where parents can't be on campus at the same time, or if one parent can't be physically near the child, does that change their power to make decisions along with the IEP team?
So if a court limits, so if a judge actually limits a parent's rights, then yes, it could be that you have bio mom, bio dad, and bio dad's legal rights have been limited by a court. Bio mom provides that document to the district. Then yes, the dad may very well, his decisions be disregarded. He may not be invited to IEP meetings, but that's a rare circumstance. The general rule is you might have both parents still have legal custody or shared custody. And even with the restraining order, we get that all the time. And we're not the police. We're not required to implement or enforce restraining orders. That's going to be the responsibility of the protected party. Sometimes, and we also should not hold two different IEP meetings. That is IEP meeting for parent A and then a separate IEP meeting for parent B, because by definition, you're excluding a parent from one of the meetings and you're never going to have identical discussions. Instead, you hold one IEP meeting and a parent who says, I'm not going to show up here if you have that stepmother there. I don't want to see her. Well, then don't come to the IEP meeting. Or you could participate by telephone. But we are responsible for policing mom and dad's personal issues. And my suggestion when this occurs is for you to go forward and try and talk with the more rational parent to bring some civility to the IEP meeting. Because if the bio mom is really upset that stepmother's going to be there, can we ask maybe have dad come and not have the stepmother? Can we try and be the adults? Because again, we're trying to help the kids. And then real quick, did that answer your question, Rebecca?
Yes, thank you so much.
And then I have a question here. If you're not NCSP, no ethical duty. No, what I'm saying is if you have an NCSP, Nationally Certified School Psychologist, you absolutely have an ethical duty. You also will have an ethical duty if you belong to your particular state affiliate. And even if you don't belong to your state affiliate or to NASP, you still have a personal ethical duty. So I just pointed that out. You can lose your NCSP if you don't act in an ethical manner. But I'm not saying that if you're not a member or if you're not a member of NASP or your state affiliate, you still have an ethical duty. And ultimately, we got in this profession for the children. And that should be your guide stone. I think, all right, so eligibility. So eligibility, it's a three-part test. So having a disability is just the first part. You have a disability. You have to have a disability that adversely affects your educational performance and requires special ed. So for example, you have a student with attention deficit hyperactivity disorder. That alone is not going to tell you whether or not the student is eligible. What you're also going to need to know is this adversely affecting the student's educational performance? And even then, does the student require special ed services? Because if it does adversely affect, but this can be met through sitting in the front of the class, maybe having some questions read, additional time, small group setting, then you might be looking at a 504 and not special education eligibility. One other thing under adversely affects is not just your grades. That's the single most important thing. And then three things, because we're in the field of education, so we love things by three. Grades are the most important, but that ain't all it. The other thing is behavior. Is a student ending up in the principal's office? Or school phobia, school anxiety. It used to be all the kids had ADHD. Now all the kids all had bipolar disorder. Now all the kids have generalized anxiety disorders. I'm anxious about the number of our kids that are anxious. So school phobia, school refusal, that would also trigger potentially adversely affecting educational performance. And then the third one, and then you can think of Dr. Sheldon Cooper from Big Bang. He probably, and because I guess they're coming up with a Little Sheldon show. So I'm sure he had good behavior. I'm sure that he had great grades, but he had the issue pragmatics almost certainly. So if a student's their performance can be adversely affected, academics, behavior, pragmatics. So next slide. The other thing just to share, depending on your state, you probably have 13 different eligibility categories: specific learning disability, other health impaired, autism, emotional disturbance, or your emotional disturbance label for your state. The courts don't care so much what the label is for the student. Labeling a student is interesting. It allows them eligibility, but the label does not drive services. The student's needs should be driving the services. Every area of need should have an IEP goal provided by a service in the least restrictive environment. So sometimes with our systems issues, school districts might get more funding if they have a low incidence disability, but that's not the student's issue, that's our systems issue. Our purpose is if the student is eligible, regardless of category, we have a duty to meet the student's needs. So I'm trying to give you the freedom and flexibility. If you're getting in a tussle with parents over a particular disability category, can we all agree that they're eligible? Great, now let's focus on the student's needs.
That's interesting too, because I feel like we sometimes get hung up on that as school psychologists. Like we want to get the label right. We want to, you also said that every area of need needs a goal. Is it okay if we say, okay, this is an area of need, but it can be addressed through accommodations in this particular case, or would every area need a goal too?
Every area of need should have a goal, and you can have Swiss Army knife goals that might address multiple areas of need. And again, this is where the area of needs adversely affecting the student. So if it's adversely affecting, there should be a goal. But if it's just an area that's, Carl sort of needs something in this area, but it's not arisen to the level of adversely affected, then yeah, that might be just an accommodation to address my need. But again, for special education, our job in special ed is to work ourselves out of a job and give the student the skills that ideally they would be able to graduate from special education and go back to the general education setting. So part of our job is to identify the needs and teach the student, give the student the skills to be able to ameliorate that, adapt to that, accommodate for that, and to hopefully eventually, again, exit from special education. Did that answer your question, Rachel?
Yep, for sure. Thank you.
Looking over, do we need to go by the manuals, use descriptors, or we should use 85 to 115 as the average range for every test? Either, unless you have some specific state law. Basically, imagine you're getting into a hearing, you're getting in front of a judge. Judges are smart folks, but you need to explain it to them, and you're the school psychologist. So I've seen the plus or minus 1 standard deviation, 15 standard score points. I've seen the descriptor, but certain tests use different qualitative descriptors. So you're going to have to make sure that if you are using descriptors that you're consistent throughout your report. Because if in one section you're saying something means low to average and another it means, I don't know, significantly below average, but it's both referred to a standard score of 82, you're going to confuse the administrative law judge. So just make sure your report reads internally consistently. Okay, next slide. Dyslexia, dyscalculia, dysgraphia, next slide. So here's a dear colleague letter. So basically what this letter says, first paragraph, and again the quotes, this is taken straight from the letter. There's nothing in the IDEA that requires the use of these terms. There's nothing in the IDEA that precludes the use of these terms. You might have some state law specifically on this, but if you're defaulting to the IDEA, then you can use or not use these terms. If parent comes in and says, I went to Dr. Charges a lot, and my child was diagnosed with dyslexia, and here's the report that says my child has dyslexia. It's like, great, fine. Then you can go and put that in the present levels of performance, reference that in the student, in the performance of the student, but then ultimately we're going to do our own assessments on this issue. The other important thing, and I mentioned it earlier, is the third paragraph. Again, label, disability, name does not drive services. That's going to be based upon the student's needs. And again, you see that in the third paragraph, which basically, for those of you that don't have the materials in front of you, the IDEA does not dictate the services or accommodations to be provided to individual children based solely on the disability category in which the child has been classified or the specific condition underlying the child's disability classification. Therefore, we're not going to dictate the feds to individual states that you have to use a particular method. So there's nothing under federal law that says you have to use Orton-Gillingham or Slingerland or any of those programs. It's up to your district. Next slide.
I have a question. One, what do you think about states that are non-categorical with their eligibility? I think there's one state, I want to say Iowa or Illinois or somewhere that doesn't have categories at all. Is that something that is easier or more complicated? Or
I think not having worked there, although interestingly enough, my brother is, and I'll just share for the whole universe out there. My brother has a child on the spectrum, and he's in Iowa, so I'll have to follow up with him on how that exactly works. I think probably if there's no categories, that it's going to be harder to say eligible, not eligible. What are the students' needs? I would think so, but I'm not aware of the case law. And ultimately, again, the case law says we don't care what category is. We want to look at the students' needs.
gotcha. And then the other thing that I've heard too is that people, although everyone seems to acknowledge that eligibility or category doesn't drive, what special ed services look like, I have heard people say that, they want the ID label specifically because of what happens after graduation, that can be a gateway to different services or more services. I'm not sure. Is that a consideration or,
Yeah, it is, but we have a job for students 16 individual transition plans. So we have a responsibility to come up with a transition plan to help the student once they graduate from high school with a regular diploma, or they age out, which in most states is going to be after the age of 21. But ultimately, we're not responsible for generating the most recent IQ test for a student in their spring of their senior year so they can use that for college. That's going to be the responsibility of the parent or when the student goes to college under Section 504. That said, I do think the ID label, which used to intellectual disability, which used to be mental retardation before the federal law, Rose's Law, changed the nomenclature, that's a pretty significant label. So the prognosis, the learning interventions that you would have for a student with autism and comorbid ID is going to be very different from a student that just has autism. So I do think that for the ID, there is some importance with that label. But long answer, Rachel.
Okay.
The next slide with dyslexia. So this is the federal law. So if you look at this, specific learning disability, and then it goes through, and this is 34 CFR 300.8 C10I. And what this says is basically, what is an SLD, specific learning disability? And it goes through, including conditions such as perceptual disabilities, brain injury, minimal brain dysfunction, dyslexia. So that's where in federal law, dyslexia will be referenced. Next slide. Most states, California law is similar to Washington state, similar to a number of other states. They don't have a specific eligibility category for dyslexia, dysgraphia, dyscalculia. What they have is those fall within under the umbrella of specific learning disability. So this is a Ninth Circuit case that fairly recent, one stop below the Supreme Court. And what they said is the parents came in and said, we wanted an assessment specific for dyslexia and dysgraphia. Washington state does assess an area of suspected disability, such as reading and writing inefficiencies, but they do it under the umbrella of specific learning disability. That's what Washington state did, and Washington state prevailed. Because again, parent comes in and says, I think my child has X, Y, or Z, like autism, for example. The autism we know as school psychologists is now autism spectrum disorder in the Diagnostic Statistical Manual 5th edition. But back in 2004, when they came up with the legal definition of autism, we were back with the DSM-4TR. So a medical diagnosis of ASD may or may not equal an IDA disability of autism. So when again, a parent comes in and says, this is my child's disability, poke at that a little more and say, what is the symptoms associated with that? And then we have a duty to assess in all areas of suspected disability. Next slide. And then I've got just a couple of questions real quick. What about when you have a student who's identified as speech or language impaired, but they need tons of academic supports? Our SLPs really don't like this. I appreciate the SLPs may or may not like that. But what you need to know is special education is much like Disneyland. Once you have a ticket and you have an eligibility, you're admitted into the park, you can go on any of the rides. There's no more e-tickets. So you can go, if a student has a speech or language impairment and they happen to need specialized academic instruction or education-related mental health counseling services to address their needs, then we have a responsibility to do so even under just SLI. It may very well be that the student might be eligible under SLI and SLD or something else, but your speech language pathologists need to think beyond their little box of their particular profession. Another question. Okay, so it's a question. We have teachers who say Johnny, specific learning disability in reading, is struggling in math to push for math services. But when is it a struggle and when is it a need? That varies again from state to state. And there is good case law that a C, we see is average. If the student is getting C's or above, then that's probably not going to be something that's adversely affecting them for which we need to provide special ed services. Student is getting below a C, then yeah, there's a good argument for that. And this is not, there's no black letter law on this, meaning I can't give you a one-size-fit-all legal definition. It's really going to vary from case to case. And how is the student functioning in the general education classroom? That's where you guys go in and you have the teacher that says, yes, Carl has these difficulties in math because I'm hoping you'll take them away during the math period into the whole special education room somewhere. Our job is to go do our assessments, but then also go in the natural environment, observe Carl, see how he's doing there, do curriculum-based assessment, and then follow up with the teacher, because it may be, again, Carl's needs can be addressed in the general education setting. The teacher just needs the general education tools. Okay, PSW. So I'm not going to say a lot about patterns of strengths and weaknesses. What I'm going to share with this is under the IDEA, under 2004, PSW really wasn't around. So the law says very little at the federal level. Some of your states may have some language on this. In California, we have one sentence in the law regarding what PSW is, essentially. What that means is we are creating case law, and I'll show you an example of that in just a minute. There is significant controversy regarding PSW. There is a nice, rich food fight going on in the literature. I'm agnostic on this issue, except to say, I was trained in the discrepancy model, and we've been hating the discrepancy model since last century. We really have. But coming up with a substitute for that has been difficult. We tried to do that with response to intervention, and generally that has not been successful across the states. So now we're looking through the literature at PSW, and what I will share with you is, rather than run off with this quick new toy or this quick new process, please read up on this. Please make sure it's doing what you think that it will do for your district, for your students. And if you are going to switch over to PSW, please get the training before you move forward. So then I have a bunch of literature there. And if anybody wants to send me an email, my email address is at the end of the slides. I'm happy to send you any of the cases that I've talked about here or this literature. It's yours. I'll send it to you. Have a blast. Make your own decision. Okay, next slide. There was one case in California on PSW that basically said PSW is okay, but there was no in-depth legal analysis. And that was 2016. Next slide. Then we had a more recent, December 18, 2018, Temecula Valley. So this was a very detailed administrative law decision. I think the administrative law judge didn't fully understand. And that's the danger too, guys. Administrative law judges are smart folk, but they're not school psychologists. And it's our job and the job of your attorney at a due process hearing to ask you, the witness, the questions, to give the judge the answer to be able to find in the district's favor. And so if your attorney doesn't do their job to get the information in front of the judge could rule against you. So if you read this case, you would think that the school psychologist did not know what she was doing. But I'm here to tell you the school psychologist referenced in the case, incredibly smart, incredibly gifted. The judge, however, Once the judge makes a decision, the judge tends to write the decisions in favor of that and disregards any of the positive things that might, the judge tells a story in their decision. And if there are facts that aren't convenient for the judge's story, then the judge does not emphasize those. So I give you in here, and then you could flip to the next slide, next slide, next slide, next slide, and then the very last slide, right there, stay there. So basically, the judge didn't understand outliers for PSW. The judge didn't understand the difference between 0.05, 0.01 significance level. The judge didn't understand how the recommendation for eligibility or non-eligibility was generated. So the judge basically found that because the assessment was flawed, then the district's ability to go and exit the student from special ed for a student who had 112 IQ was flawed. So the district lost on this issue. My understanding is this court case is up for appeal. So stay tuned. And that's all I have to say about PSW. And okay, IEEs, real quick, IEEs, independent education evaluations. Basically, what you need to know is under federal law, if a parent disagrees with your assessment, then the parent is entitled to request a assessment paid for by your school district. And your school district has to either agree to pay for the assessment or file for hearing to defend the appropriateness of the assessment, which is where many of you may end up in a due process hearing defending your assessments. A parent does not have to provide a detailed description. Yes, I think you should have used the 0.05 for the statistical significance level, and you shouldn't have used the DAS, you should have used the unit. Parent doesn't need to go into that depth. There's a great federal district court case where the parent's sole objection that allowed her to request an IEE was the assessment done by the school psychologist was, quote, end quote, stupid. Really, that was all that the parent had to say. I disagree because the report was stupid. That triggers her right to ask for an independent educational evaluation. Go to the next slide. The district has to go and respond to the parent's request without unnecessary delay. How long is that? It's not in the law. So when it's not in statutory law, then you look at case law. So 3 months is too long, 74 calendar days to respond to the parent to whether or not you're going to agree to pay for the assessment or file for hearing. 55 days was too long, but 53 days was okay. And in another case, they allowed 41 days, legally defensible best practices, even during the summer. Parent makes a request for an IEE. District should respond in 30 calendar days. Next slide.
Interesting. I've had parents try and request an independent eval before I've done my eval. So they just don't like me or don't want me to be the one to do the evaluation. They want their private psychologist to be able to do that. But they need to go, they first need to have us to have a shot at it before they can contest anything, correct? That's how it works.
Rachel, yes, you're absolutely correct. An IEE is an independent education evaluation where they disagree with our assessment. And if we have not completed assessment, there's absolutely no right to an IEE. And it's fairly common that we will get that I only want my private assessor, or they've already had the assessment done. And now they say, we want eligibility. And we're like, no, we have a right to assess. No, we get to assess first. Parent disagrees, then that triggers the right for an IEE. And I see in the comments from Rebecca that school districts out there charging $5,000 for private assessments. Out here in California, they are charging between $5,000 and $8,000 with these outside assessors. But here's the kicker. Sometimes that's less expensive than going to hearing, so some school districts agree to do that. I would very much prefer that school districts do go to hearing for two big reasons. First, they're going to hearing to defend your assessment. So they have faith in you and they have faith in your competence. So I think it's important for districts to defend their school districts and show that they trust their results. The second reason why I think more districts should file for hearing rather than pay for IEEs is because, okay, now you've just spent $5,000 of district money to have Dr. Charges a lot do an assessment that's going to find the student gravely disabled, make all these recommendations for services, and now the parent files for hearing against your district saying they would like all these services that based upon the evidence in the report that your district paid for. Okay, so now FBA and BIPs, because I want to give time for questions still. The good news is, under the IDEA, there is no legal definition of what exactly a functional behavioral assessment is. There's not, you have to do A, B, and C, or you do these 5 points, or it has to cover these 7 areas. Federal law gives you nothing on this issue. Your state law might. California used to have law on this, and they got rid of it and basically went and deferred to the federal guidance. And I give you this, and I'm not going to read all of this for those of you listening to this. You'll have to look at the slide. But basically it describes, and I give you the legal citation from the law and from a case about the purpose of an FBA. Next slide. And I give you a OSIP letter about the requirements of an FBA. It is an assessment. You do need an assessment plan. And there's a good recent OH decision that goes out of California from May 25th, 2018, that talks about a good FBA. So if you're working and doing FBAs, send me an email asking for this case. I'll be happy to send it to you. So no definition for an FBA. What about a BIP, Behavior Intervention Plan? Next slide. You'll be happy to know again, we have no legal definition of what exactly a BIP has to be. That's good news and bad news. The good news is, as long as you're doing what's professionally appropriate in your local community, and you're prepared to testify under a penalty of perjury, that this is basically best practices in developing a BIP, congratulations, you should win at hearing. The bad part with this is kind of what Rachel talked about earlier, where there's no clear, like for eligibility, where there's no clear definition, then it allows for a wide variety of what's a good BIP and what's not a good BIP. And where the law doesn't define it, it turns it over to case law, which is unfortunate because now a school district's spending money on attorneys rather than on kids. In the same fashion, I give you, there's a Mill Valley Elementary School District decision and a case out of Antioch, fairly recent, from May 9th, 2018. It talks in some great depth about a legally defensible BIP. If you're doing anything in this area, please send me an email. I'll send them to you. Next slide. And this is the question parts, and I'm looking over at the questions.
And we've had a lot of questions come in and a lot of comments, so we're trying to kind of ferry them over to you. But I've told people that if something gets lost in all these in the chat there, to for sure type it again. So if you haven't had your question answered, type it out again, please.
So Rachel, if you don't mind then, rather than me looking over here and trying to just decipher the questions, if you, Eric, and Rebecca just ask me a question, I'll be happy to answer it until you guys tell me to stop.
Absolutely. We've got a question just in. Corey asks, does it mean that if there's an already identified student and we want to do an FBA, we have to do a new MET, or can we just get parent permission outside of an MET?
So, and that's the letter to Christensen that I referenced that says if you're doing a screening, you're doing an observation, you're looking at a classroom and you're talking about systems, then you don't need parent consent with an assessment plan. But if you're individually assessing a student and you're looking to identify their behavior and then come up with a goal with replacement behavior, the things we do with BIPs and FBAs, then OSIP, and that's the legal citation that I had letter to Christensen, says you're supposed to get informed consent from the parent to do this assessment. How that looks like for your particular state is up to you, but I'm just sharing. If this goes to hearing, you're going to have to demonstrate that the parent gave written informed consent.
I saw a question about somebody wanted to know if you have any thoughts or recommendations for if you're a school psychologist in preparation for being involved in a hearing or a court case. Like what should we be prepping? Is there anything we can prep?
Sure. First thing I will share with you is I am doing a workshop, a documented session on NASP on this issue. It's like, I think 90 minutes or so, and I'll talk through that and talk about how to answer questions, how to give information to the judge, what you should be looking to go study for beforehand, and even give you some sample questions that I've used in an actual hearing. Basically, you don't need to memorize anything per se. Everything should be in evidence. So your report should be in the evidence for the hearing. What you need to have is familiarity and fluency with your report. And you need to be able to explain to a smart individual, the judge, the reasoning in your report, why you found what you found, what was that based upon. You need to appear credible. So do your studying, be prepared to be asked psychometric questions like I showed you in that Temecula Valley case. Because if you are not able to explain something to the judge and you're the expert, you're going to lose credibility. So review your materials, become fluent, don't try and memorize, but know where everything is in your report. And then at the hearing, work with or before the hearing, insist to spend time with your attorney. Your attorney, if they're doing their job appropriately for your district, should be doing witness preparation with you, going over the facts of the case, talking about everything, talking about your report, your input, what you did. You should never, ever, ever all of a sudden, hey, Carl, be at the hearing next Wednesday. That should never happen. You should have all this preparation associated. And I would encourage you, if your district hasn't been doing that, say, you know what, I'd really like to get some witness preparation here. I think I need more to be successful.
That's good. We had a couple questions about IEEs. One about who decides on who does the evals, and then the other, can parents specify what tests?
So a couple of things. First, specifying the test, under federal law, no. We assess in areas of suspected disability, but a parent under federal law has no right to say, yeah, I don't want you to use the WISC-5. I want you to use the original lighter. Use that with my child. We don't have to do that. We get to pick the assessments. So that's the first thing. Second, after we've done all the assessments, we have a report. Parents disagreeing with that, parent can then go and request an assessment, and again, in an area of functioning. They could say, I want you to run through the DOS or the KBC, but they have a right to assessment in that, again, area of functioning, not necessarily a specific assessment. So again, under federal law, no, the parent doesn't have a right to that. And what was the first part of your question, Eric?
Do parents have the right to select who does the eval for an IEE?
So districts are allowed to come up with criteria, and criteria can include limits on cost. It can include limits on credentialing. So if we're doing an issue with cognitive assessment, then we're going to want to have a psychologist, a school psychologist. We're going to want to have someone with psychologist in their name. We're not going to have the speech language pathologist giving the cognitive measure. And so districts can and should have criteria on that. We can also put limits on cost, but the limits in the cost have to have an escape valve that the parent, we can say no more than $2,000 for a psychoeducational IEE, but we have to allow the parent to provide evidence to say, in their child's particular unique circumstances, we need a $4,000 assessment. Generally, the court cases have not gone in parents' favors on that issue. Unique really means highly specialized and unique. And just because you may not be an expert on a student's particular medical disorder, but you're otherwise qualified as a school psychologist, that's probably not going to be unique enough to go beyond the cost criteria.
That makes sense.
I wonder if we can squeeze in one last question. Yeah. We have a question. What about in a teacher consultation problem-solving relationship, instructional consultation, behavioral consultation, is parent consent required for CBA and behavioral observations for gen ed Public school.
Okay, so what I'm hearing is we used to have response to intervention. Some states do, but many states have moved on to MTSS, multi-tiers of systems and supports. So the law specifically allows for screening, and it allows for use of, through MTSS RTI, interventions such as some behavioral interventions. So for a general education student, we can come in and do a FBA-like and develop a BIP-like in the general education program without doing an IDA assessment. In the same fashion, we can provide some RTI or pre-intervention speech-language services, occupational services, etc. That's legally permissible, and then you would not need to get written informed consent from the parent. But careful, because you also have a child find duty. So we're always balancing, is this just a general education issue where I don't need go to the IDA route and I'm going to do this MTS intervention, pre-referral intervention, or do I have sufficient information that this is triggering my child find duty and I need to go straight to an IDA assessment? That's going to be case by case. What the law does specifically allow, and there's guidance from OSEP on this issue, you can go and do a general education, FBA, and even a BIP without getting through the IDA process, without even getting informed consent from the parent. But be careful.
So much great information. I think we'll wrap up. I'm trying to, do you guys see any like pressing questions that we can squeeze in? I think you've answered a lot of questions tonight.
Definitely. There are a lot of questions, a lot of great comments. We appreciate all the conversation, and we will continue to sift through and get them posted. And if there are any questions over the week after the live broadcast airs, we'll try to get them to Carl and post them on our social media pages.
Okay. Thank you so much for joining us and taking time away from your busy schedule. I know you present all the time, all over the place, so we're really lucky to have scored you.
Thank you.
Yeah. And then I wanted to remind everyone, one, that School Psych Podcast will be at NIAS presenting, and that's coming up pretty soon. So if you happen to be at NIAS, give us a wave or something. And two, our next podcast would be on 10/20, and that will be with Dr. Joel Snyder. So we hope to see everybody there. And good night, everybody.
Night.